me. The live session is coming up next. So if you've got a consumer law question, you can give me a call on this number, or you can join via the live chat on YouTube, or just send the question via Twitter and I'll display it on the screen. Just a couple of quick rules. Please do not tell me the name of the company you're complaining about. Just say it's an airline, a retailer, or a dodgy builder. All of that coming up next. Welcome to the Consumer Lawyer YouTube channel by me, Dean Dunham. On this channel, you will find consumer law advice videos, breaking consumer news, scam alerts, and every Monday at 8 p.m, I'll be doing a live stream where you can call me, text me, or join me on live chat on YouTube and ask me any consumer law questions that you have. But who am I?
Police have had an allegation about you. Many people are thinking that this has happened, and some of the newspaper headlines have not. People seem to have made a mistake. They've purchased products to sell to consumers, to Exeter or whatever it happens, for showing the trustee you're in breach of contract because I've not had it for such a long time. I now.
I hope you find the channel useful, and I hope it helps you to not only understand your consumer rights, but to assert them as well. Please do subscribe and press the bell button because that will alert you when new content has gone up, which will be on a daily basis.
Good evening, everybody. Hope everyone is good. So welcome to this first of my every Monday night live streams for Q&As. I'm going to try and keep this to just answering questions rather than talking about updates in law. Now and then it may be useful to do that, but I'm going to try and get through as many questions as possible. I have been receiving lots of your questions and I'll try and fly through them. The phone lines are also now open. I will say this, next week we are moving to a new bit of software for the phone line. So if they don't work great tonight, forgive me. We've never done a phone in before on this channel, so this is new. Hopefully it will work well. So I'm going to quickly just jump to straight some of your questions immediately. Also, I will be giving a quick update on the CMA to Teletext holiday refund customers shortly, because I had a response from them today to the communications that I sent them about our last live stream, which was dedicated to Teletext holidays. So hopefully I'll be able to come back to you about that very, very shortly in about 10 minutes time to give you a bit of an update there. As I say, you can send me questions via the live chat. You can tweet them and I'll read them out, or you can give me a phone call, whichever one you would like to do. So let's go straight to the calls. Might be one moment. Hello. Hello.
Hello.
Good evening. Can you hear me? Can you hear me okay? Hello.
Can you hear me?
Yep, I can hear you. Can you hear me? Oh, the wonders of live call-ins. Hopefully, if you're watching, please do call back. We may get some teething problems with calls. Whilst I'm waiting, let me just go to some of the questions I'm receiving here. I made a Section 75 claim, but it's been refused. I used PayPal. Is this right? This is a question I get all the time, actually. It really is a real issue because for Section 75 to work, you have to pay direct. Now, what I mean by that is your credit card has to be paid direct to the seller, the trader, or anything else like that. So basically, if you are buying a holiday, if you're buying something from a retailer, Section 75 only works if you have paid direct. So what's the difference with PayPal? Well, what happens with PayPal is that you pay PayPal and PayPal then pays the trader. And that means we lose the causation. So the causation link is broken. And for that reason, Deborah, that means Section 75 does not work. The good news is that PayPal has its own version. It's not Section 75, but it's got its own version of a dispute resolution scheme, if you like, if something goes wrong. So you'll have to go there. But let me just give this warning, because I'm always telling people Section 75 is a wonderful insurance policy if you are buying goods, especially from overseas or online or somewhere like that. Use your credit card. You get this great protection. Only works if you pay direct. And for that reason, I always prefer not to pay through PayPal. If the trader says it's the only way to pay, often if you telephone them or email them, they will give you an alternative. I'm not trying to advocate that PayPal's terrible. It's not. Neither are any of the other online payment platforms that do the same thing, but you do lose this really good protection when you use it. And it's something to remember. And Deborah, you've obviously had the issue with this, and you've come across why I'm saying this. So do be very, very careful. Next one here, Sean says, I have started a claim in the small claims court. What happens next? Lots of people are asking me this question, actually, because lots of people are issuing proceedings against holiday providers and various people like that who have failed to give them a refund so far. Look, it's a really simple process. The small claims court is designed for non-lawyers. So lawyers are not supposed to represent clients. They can, but the system is designed for the litigant in person, as we call them. And it's designed for consumers to go along without a lawyer. So, Sean, you'll know you've gone online, you've filled out an online form, you've lodged your claim. So what happens now is the person or the company that you're claiming against will now have received that claim. They'll be given 14 days to acknowledge it. And if they do acknowledge it, they'll have another 14 days to put their defense in. So for you or anyone else who's done this or gone through this process, to start with, for the first 28 days, nothing for you to do. You sit back and wait to see what the defendant says. Let me pause there for a moment, because what I'm seeing is those that are doing this against holiday companies, quite a few of them are just not responding, or they're asking for extensions of time. So they're asking the court for more time to file their defense. If you get asked by a court whether you object to this, my view is to say, yes, you do. Now, ordinarily, I don't say that, because ordinarily it's good to give the other side some time, because you may need some time later on with a deadline that you've got with them. I'm not saying that here, because these holiday providers or event providers, anyone who's had to cancel because of the pandemic, they're only asking for the extension to buy time. It's not because they need more time to respond, because to be honest, Sean, if you're claiming because of an event that's cancelled, whether it be a holiday, a wedding, or anything like this, there is probably no defense. Therefore, I would say to them, I'm not accepting it. But that's what happens next. Let's go to the next stage after that. You'll then have to put your witness statements in, which is where you explain in your terms what happened. So if it's a holiday, you'll say, well, I booked the holiday on XYZ date. I paid this much money. It was all cancelled because of COVID, and so on. Now, if you go to my blog site, which is the consumerlawyer.blog or .co.uk, both of them work, you'll find that I've done lots of pages in relation to Teletext holidays and various other brands. On some of those headed templates, you'll find a template for small claims court. So it's what's called a particulars of claim, and it sets out what you have to type in there. And also, very similar, you'll do with the witness statements as well. It's really important that you put all of the information down, because this is your time to get your case across. This is your time to get all of your evidence out. So when it comes to the actual hearing, which, Sean, is the last step of the process, obviously, you'll be well prepared and you'll have everything ready. So that's what happens next. Few steps. It's very straightforward. If I made it sound complicated, it's not. Don't be put off by it. It's actually very simple. Question here. I purchased a used car on the 8th of January. I have discovered a major engine management issue. I want my money back, but they will only offer to fix the issue. Surprise, surprise. Well, that's what nearly always happens with used cars. And I get calls like this when I do my show on LBC nearly every week. And that question is almost identical to what I always hear from people. Look, this is what the situation here is. We've got a law, and it's called the Consumer Rights Act 2015. Anybody who listens to me regularly or reads anything I write about will know that it's one of my favorite pieces of law. These are words that I say all the time, Consumer Rights Act, because it greatly empowers the consumer. Now, what you need to do is to go back to this garage and say, under the Consumer Rights Act, I have what's called the short-term right to reject. Those words are important because what that means is if you're going back with a fault with the car, and let me stop there a moment, this doesn't only apply to cars. So if you've got this issue with a washing machine, oven, or any goods at all, the Consumer Rights Act says within the first 30 days after purchase or delivery, whichever one comes later, you have the right to say, because these goods are faulty, I'm rejecting them. So in this case, the car's faulty, clearly. That means you can go back and say, here's the keys back. I'll have my money back, please, because we're in the first 30 days. Let me give you a quick warning about this. Us lawyers talk about something called burden of proof. What that means is which of the two parties has to prove their case. Now here, when you're in the first 30 days and you're claiming that the goods, in this case, the car, is faulty, you have the burden of proof. With this question, it seems obvious that the car is faulty because there's this major engine management issue, which of course hasn't arisen on its own. So it seems like there is an issue with this car, which is very common with used cars. Not that particular issue, but with something to go wrong, usually within the first 30 days. This is one of the reasons why we have this 30-day rule. We didn't used to have it. It was mainly driven and inspired by car purchases. So use it. So there you go. You don't have to accept the repair. You don't have to accept anything in the first 30 days apart from your money back. Let's go to another question. So Wilma Neal says, what happens when Teletext took my money even after the holiday was cancelled? I'm not sure what you mean by what happens, but let's deal with this question in two parts. Should they have done that? Should they have taken your money even though they knew that they were never going to be able to supply you with a holiday? Answer, of course, no, they shouldn't have done that. If they were able to say, we didn't think the holiday was going to go ahead, but we weren't sure because we weren't sure if the lockdown would have been lifted by the time the holiday came up, then they'll have a right to say, well, this is why I've not done that. But basically, they shouldn't have done it. I would go back and say, I'll have my money back, please, because you shouldn't have done that. And if you pay by credit card, make a Section 75 claim and make the point that they took the money even though they knew the holiday couldn't go ahead. Got a call coming in now. Let's see if we can take this. I think it's from the same person before. Let's see if we can get it to work this time around. Hello? Can you hear me?
Hello?
Hello there.
I can.
It's working this time. What's your name?
It's working. Yeah, Adrian Matescu.
Hi, Adrian. What's your question?
Right. I have a question. I've recently taken to a small claims court, a group company, and
Okay.
I've taken basically their UK representative because this group company has affiliates and subsidiaries in throughout Europe, in every single country of Europe.
Okay.
Now,
Adrian, what have they supplied you? What's the case about? So you've taken them to court. They've done something wrong. What have they done?
no, actually, it's a small claims court because let me be plain. Paper held money in my account, and they wouldn't release my money.
Okay.
So I've taken them to court. Now it's a big battle. I've won, by the way, and now it's a big battle because I've taken their UK representative to court rather than their headquarters in Luxembourg.
Right.
But this is a question I've asked solicitors. I've asked what do you call them? That.
So Adrian, so Adrian, you've won the case. Are you asking me?
Sorry?
Are you asking me how you now enforce this judgment, or is the company in Luxembourg saying you sued the wrong company?
I've used wrongly, by mistake, I've used their trading name rather than a company name.
Right. Okay. And are they?
So I've used PayPal instead of.
Yeah. By the way, this is something.
Right. And now
Go on. Sorry.
Yeah. Go on.
No. Carry on. So what's happened now?
Well, now the PayPal UK Limited, because this is the company name, their name here in the UK. They've tried to set aside the judgment,
Right.
but
Okay.
it's been denied. And now the judge has asked me to apply to change the name of the
Right.
company.
Okay.
But then the big question is, who do I change it to? I change it to PayPal Luxembourg, which is
Okay.
the people that have got basically the agreement on PayPal's website, or can I go for PayPal UK, which is the
Okay.
affiliates, the subsidiaries here in the UK?
So Adrian, let me jump in
This is
because
the question I've asked.
I can understand the question. Let me jump in now. Let me first say this, because I know there's many other people watching that are going to be going to the small claims courts. I said it at the start of this live stream because they are suing predominantly at the moment holiday companies. I know that's not the same with you. And one of the things I've been telling people is make
Right.
sure you sue the correct party. Don't sue a trading name. Make sure it's the right party, because if you don't do that, by the way, anyone watching with Teletext Holidays will be thinking, yeah, he did say that. He told us this. Don't call them Teletext Holidays. Adrian is a good example why I said that, because it gives rise to an opportunity to the defendant to come back and say, actually, you've sued the wrong party. So Adrian, the answer to your question is you need to think about who you actually had a contract with. It sounds like it was the Luxembourg company, and therefore that's the company that you need to put down on the form. You're very lucky here because the judge is allowing you to change this around. They could have just kicked the claim out, but that's what you need to do. It's very important that you get the right company. Whoever you do put down on this form, make sure you can prove that you had some kind of contractual relationship with them. So if there's any contract or anything at all, make sure that's the name on there. And if it is, then that's the right party to sue.
I'm losing you. So.
Oh, did you hear me, Adrian?
Well, I do understand. I understand where you're coming from, but going through the agreement, which is with the PayPal Luxembourg company,
Yep.
it says under intellectuality and claims and disputes, it says that the term PayPal, which is the trading name, and PayPal and all the websites and everything that belong to them, and all the affiliates, subsidiaries, and all the other group companies that fall within their control. Now, PayPal UK Limited, this company here in the UK, is one of those companies that fall under their control, and basically they're the UK representative for PayPal Luxembourg.
Okay, but
So
which
it's the
one
same
did
company.
you actually? Which one did you actually do business with? I mean, what did they do for you, by the way?
Well, basically, you've got an eBay account, you sell things through eBay, and you get paid for your PayPal account.
Oh,
like
I
everybody
see.
does. The
I
normal,
see. Okay.
yeah. And
So
they've held my money in the account.
okay, I now understand. I'm not going to mention that too much because we try not to mention brand names, but I now know who you're talking about. So what you need to do is you need to
Yeah.
sue the UK limited company. That's who you need to sue, because I think that's who your contract was with. Look, you would have had some terms and conditions. Definitely. If you haven't, I would ask them, can you supply me with the terms and conditions that apply to our transactions? And they will clearly say who you transact with. If I'm right, who I think you're talking about is going to be the limited company in the UK. But as I said, it's very important that you get the correct company, because if you don't, you run the danger of this case being kicked out. And even though you've won, it'll be a fruitless victory, be a hollow victory. So I think you need to make sure you do that.
This is
Yeah.
This is the thing, because when I've asked on the online chat in my PayPal account, in a messaging system, I've asked them for the UK address, and they gave me a UK address which belongs to PayPal UK Limited. They haven't specifically said the company name is this.
Well, I would probably say that's
This
probably
is the reason why.
I would say that's probably good enough, because you can produce that email to say they held out to me that this was the entity or the company that I was dealing with. Therefore, this is the company.
Misleading.
This is the company I'm going to sue. Adrian, that's what you need to do. If you do that, I think you're going to be fine. Again, let me just say this to everyone else listening. So important that you sue the right company. I'm stressing it because I know how many people at the moment are going through the small claims court. Just stop for a moment before you lodge that claim and make sure you've got the correct party. Adrian, hope that goes well. Do let me know. Let's go back to some of the messages online. So Adrian says, hi, Dean, can I please ask if it is possible to take to a small claims court the UK representative? I think this may be the call I just received. Adrian, I think that's the call I just received. The answer to your question, I think I said online, is yes, on the phone, sorry. Yes, it is possible if that's the company that you contracted with. Very important to make sure that it is. And if it's not, you will be suing the wrong party again. So let's make sure that it's the correct one. Let's go back to some of the questions. I think I have another call coming in. Good evening.
Let's make sure it's the correct one.
Hello.
Hello there.
Hello. Can I speak to Dean?
Yep, speaking. What's your question?
I took out equity release about 12 years ago. I've since remarried, and the mortgage company has changed hands 3 times.
Okay.
I was now received a letter from my husband to sign, saying in the event of my death, he will vacate the property immediately.
Oh.
Surely he'll be given time to find somewhere else to live or sell the property, because there should still be cash left in the equity.
Okay, so let me just make sure there's one thing I understand, because you said, did you say
I have put this online, but I don't know whether it's actually gone through or not.
Okay, I've got lots and lots of questions coming through. What was your name again? Sorry.
Sorry, Peggy Vickery.
Okay. So Peggy, let me just ask you this. So basically, you have an equity release. Is it only in your name?
Sorry, I can't hear you.
Is the equity release only
Can you
in your
turn
name?
the sound off on the computer a minute? Sorry, I can't.
That's okay.
I've got it.
So Peggy, is it just in your name?
Yes, it's talking to me now. Yes, it is just me.
Okay, and what they've said to you is that can you sign a release to say your partner? Is it your husband or your partner?
Yes, it is just me.
Okay, and what they said to you is...
Sorry, Peggy, if you turn the computer sound off.
I'm online now, to Dean.
So, Peggy, if you turn the computer sound off. Anyone else listening, when you call in, turn your computer sound off, because otherwise it makes it very difficult to hear.
Right, I've done that.
Okay, so Peggy.
Can you hear me now?
I can. So my understanding is this. You have an equity release arrangement. They've asked you to sign a document to say that if you die, that your partner or your husband, who is it?
My husband. I married since taking the equity release out.
Okay. Is there any reason why he can't? So you took money out of this equity release, and they've now got a charge in your house, have they?
Yes, that's right.
Okay. And
I would have
does
thought
your
he'd
husband
be given
own any
time
of this
to
house?
find somewhere else. No. He's put money into it. That's beside the point.
Sorry, Peggy, say that again. Does your husband own any of the house?
Hello?
Hello. Does your husband own any of the house?
No.
He doesn't. Okay, so that's why they're saying that. Look, they have the right to say this because they need to perfect their security. I would go back and say, well, he's not going to vacate the property immediately, because to do that would be silly, because he'd have nowhere to go. But he would agree to vacate or to sell the house or to repay the loan within a reasonable amount of time. Because if you died, this property would pass to him. We call that the right of survivorship, unless you've left it to someone else. So if you haven't left it to someone else in a will, it would pass to him under the estate, and your estate would have to pay that loan off, that lending off. And of course, you won't want him to be turfed out. So just because they've sent you that form, it doesn't mean you've got to go back and sign it, because of course you've already had the equity release. I would go back and negotiate with them and tell them that you don't want to do that. I would also, if you haven't got a will, go to a local solicitor and do a will and tell them about the issue, because they'll be able to help you to solve what is actually quite a common issue that you've got with this. Is that okay, Peggy? I think that's what you need to do.
All right. Only at the moment we are self-isolating, so we don't really want to go out of the house.
Well, if you need to take some advice from somebody, everyone will be doing that over the phone or a Zoom or something like what we're doing here, actually. So you won't need to go anywhere. I would write back to this company and say, look, I'm concerned about this. Leave me to go and get some advice. Give me some time to do that. They will say yes. By the way, how do they know that you now have a new partner or husband? How do they know that?
Well, I wrote to him because of my change of name.
Right. Oh, I see. Okay.
I told them.
So let me just give you an analogy with this. Is when you do an equity release, if you have anyone else living in the house, say an adult, a child who's over 18, they'd ask you to sign exactly the same form.
No, there's just us. I have filled a form in to that effect that he's living here.
Yeah. So Peggy, the reason I'm saying this,
are at the moment.
Yeah, go on.
Ratings are at the moment. I think I owe 110,000. Okay. And I would think the property is worth about 250,000. Okay. So there's going to be some negative money to come back.
Okay. So it really shouldn't be.
Obviously he would need to buy something else.
Of course, it really shouldn't be an issue. I think what you need to go back to them and say is, let me say this first. It's quite normal. Normally they ask you to sign it because there's a child or a lodger or someone who is an adult over 18 in the house. Often it's not because of a husband, because often with your husband, you both do it, but your case is slightly different. So there's nothing unusual about this, but you can go back and say, look, it's a slightly different scenario to what you usually have because it's my husband, not a child. They also have an interest in the house. They will have some kind of a matrimonial interest in the house anyway, because he is living there with you. So go back and explain the situation. I'm sure they will agree that to change the terms of that to within a reasonable amount of time, or to repay that loan, which of course the best thing for him to do would be to, if you're leaving the house to him, to sell it, repay the loan, buy somewhere else. It really shouldn't be an issue. I hear the question quite often. Many people have this issue, and I very rarely hear that it results in an issue. And Peggy, I think you're going to live for many, many years to come anyway.
Well, I'm 80 years old now, so I haven't got that much longer.
Oh, you sound like you're 50 years old, and I think you'll be fine. You've probably got many years. Yeah. Peggy, I think you'll be okay with this. But look, go back, speak to them on the phone, see what they say. If there's any more queries, come back and let me know on Friday on LBC or back on here Monday. But I think you'll be okay with that. All right. Good luck, Peggy. Thanks for that.
Thank you very much, Dean. I'll get hold of them tomorrow.
You're welcome. Hope that goes well.
Thank you very, very much indeed.
Good luck. Let me just say this about that call, is that this is actually quite common. As I say, often it's to do with children, and often there's a child involved who's over 18. They ask you to sign the form. So Becky, I think you'll be okay. All will be fine with that in my view. Let's go to the next caller.
Well, you're breaking up. I'm on it.
Oh, sorry. Next caller. Hello.
I think you'll be okay.
Hi there. What's your question?
Hello.
Hello there.
Hello.
Hi. I've got a quick question about an appliance that I bought from a major department store retailer. I bought this appliance about 4 years ago. Okay. When I bought it, it was advertised on their website as having a 5-year guarantee, and I bought it on that basis. And even the documentation I got after I bought it, sort of the online receipt effectively says that it has a 5-year guarantee. It recently developed a fault, and so I contacted the retailer to sort of pursue under guarantee a repair. And effectively, the long and short of it, after they sent me back to the manufacturer, they basically said that it was sold erroneously as having a 5-year guarantee. It actually doesn't have a 5-year guarantee. It's got a 2-year guarantee. So I said, this is a bit problematic for me because not only, do I not have the guarantee, I also can't extend it, because normally when I buy an appliance, I will always try and extend the guarantee so that I've got ongoing cover, that if it ever does break down, I will get a replacement from them. So what they've said to me is that it doesn't have a 5-year guarantee. They will repair it for me sort of at their cost, but effectively when the 5 years is up, I can't extend the guarantee. They've also now come back and said to me, as an alternative, I can have a replacement cooker. So they said, look, choose something from our website and we'll make a contribution to it. Now, my feeling is sort of, I wouldn't be in this position if the guarantee was sold and was correctly, was correct as sold.
Yeah.
And this idea that sort of you want to offer me a contribution of about £150 and I then have to sort of put the rest of the cost of the cooker. I mean, it cost about £700 when we bought it. It's not adding up to me, and I don't really think this is right. And I mean, today I tried to sort of resolve this with them sort of amicably and not really go down the sort of legal route and the Consumer Rights Act. But when he came back today and sort of said, well, maybe £150, if I had a guarantee, I wouldn't be in this position. I would have either a full, repair and an ongoing right to extend the warranty, or they would replace it to me, free of charge, or at least up to the value of what I paid for the cooker.
Okay,
and
so
now
let me.
I don't really know where to go with this. I don't want it to get sort of really.
No, I understand. I can understand where you come from. Let me ask a quick question. So, are we talking about a guarantee or a warranty? They are different. I think it's probably a warranty.
Well, it was. Yeah, I don't know. I can't really hear you that well. It was the original guarantee that came with it.
Okay. So look, as I understand it, either they've sold it with a warranty or a guarantee. I think it's probably a warranty. It may be a guarantee, but look, it doesn't matter for the sake of this. And you thought it was 5 years. It was 2. How long have you had this appliance?
I've had it 4 years.
Okay. So basically you've had it, you should be within what you thought was going to be the warranty or guarantee. Look, this is very simple. And I think they know it because of what they're offering you. They've basically missold you these goods. That basically means you've bought it on a representation that wasn't true. There are 2 types of mis-selling. One is where they do it on purpose and one is by mistake. This is clearly by mistake. I hear this quite often where a retailer's just mistakenly said the warranty or the guarantee is a certain period of time when it's not. It sounds like it's a warranty to me because it's a manufacturer's warranty. And the manufacturer saying, actually, no, we didn't do an extended warranty like that on these goods. I think there's a few things you can do. You can go back and say, well, will you now give me a free extended warranty so I'm covered for the correct period of time? Because it's one thing then giving you a repair now, which is a good remedy under the Consumer Rights Act. But if it goes wrong again within the next year, you'll have the argument all over again. Whereas if you'd had this warranty, you'd still be within your 5 years. And that's the problem you've got. So if it was me, I'd be going back saying, okay, give me the free repair. Because if you went to court with this, the judge would say, well, in terms of the current issue, the Consumer Rights Act, which is the law, as you correctly identified, which covers you, gives the remedy of a repair. That's all they've got to do. But then you've got the secondary argument about the warranty. So I think you say to them, I'll take the free repair, but I want an extended warranty to take me up to the end of the 5-year period. If they don't give you that, then they'll have to give you some kind of other compensation. Now, the Consumer Rights Act also has this thing called a price reduction, which means these goods are not really worth what you thought they were, in this case, because they're not covered by a 5-year warranty. Will you give me a reduction in price? And of course, you could then use that to buy an extended warranty yourself. If somebody will give you an extended warranty on these goods, they may not after 4 years, I'm not sure, but that's where you need to go with it. And I would push it very hard. Now, finally, I don't know who the retailer is. You can't tell me on live on air now, but ask them if they are subscribed to an alternative dispute resolution scheme, an ADR scheme. If they are, then take your claim to that ADR scheme. If they won't do what I'm telling you they should do, and see what that scheme says. Most of them are free for the consumer, and the decision, if it's in your favor, is binding. So I think that's going to be your next step. But overall, I think you're going to be okay with this. So just to recap, take the free repair, tell them you want an extended warranty so that you've got the whole 5 years. Then you're back in the position you would have been in had they had done what they promised you in the first place. And that's what you need to do. And all the rights are in your court because you're in the right, they're in the wrong. Okay. Good luck with that.
Thank you so much. Thank you.
You're welcome. Good luck with that. Back to some of the questions. So I recently purchased a mobile phone which came with free headphones. The free item is faulty. Am I entitled to demand a replacement or repair? Well, if the headphones are faulty and it's something you've done, you've not broken them yourself, then if you're in the first 30 days, you can just get your money back. like I said earlier on, if you're outside of 30 days, then yes, you are entitled to a free repair or replacement. But let me just say this, the retailer can decide which one to give you. So they can decide if it's a repair or replacement. But ultimately, Consumer Rights Act says you're entitled to a remedy. Let's go back to the calls. Hello. Hello.
To Dean Lanham.
Hi there. Who am I speaking to?
Hi. So to Dean Lanham, the consumer lawyer.
Yeah, speaking. What's your question?
Yeah. So my question is regarding a flight. A flight that was cancelled was like 10 hours. So it was cancelled, the morning flight, and it was moved to the evening flight.
Okay.
So I would like to know if they are entitled, if they can do that, or because they only offer a refund.
Right.
So, but then at that time, our flight were much more expensive when they canceled the flight. So I would like to ask if I'm entitled for the company to book a flight in the similar time, but with a different company.
When was this flight?
Can you hear me?
Yeah. When was the flight due to take off?
So the flight that was, so what was in the past? So the flight was on the 20th of December.
Okay. I didn't think anyone was flying in December. Okay. So let me recap and tell me if I've got this right. So basically 20th of December, you were booked on a flight. I think you said it was delayed by 10 hours. So you got a refund. I guess that's because you said, I'm not going. Is that right?
No, sorry. Sorry. So I booked a flight for the 20th of December in the morning, 9:45.
Yep.
And then that was in October. But then in November, towards the end of November, I received an email saying, your this flight is cancelled.
Okay.
And then the only option, you need to move to the evening flight, which is 7:35 in the evening. And then I tried to check other flights other days, but all flights were only available 7:35 in the evening.
Right.
And the problem I had, that was for Spain. And the problem I had is that I need to go to my family to the place, and they are away out of Barcelona, so there was no public transport. So, and then I had to take a taxi for 30 miles, which is a long distance and a high price. So it was very inconvenient. So at that moment, I accepted because I was very stressed out for the whole thing.
Yep.
But I still have, my question for you is, in these cases, if the company can be, I know it's a difference between 2 weeks and more than 2 weeks. So I think more than 2 weeks, they can change the time. But I don't know if they can change so many hours because you lose one day of your holiday, you lose one day. And then at the time, there might be not available public transport, so you need to pay more money. So there's a damage to, to the user.
So let me jump in because I think I understand the question now. So basically the rule is this. If an airline cancels more than 14 days in advance, you're entitled to a refund or to be put onto a different flight, but you're not going to be entitled to compensation or to any consequential losses, which are the losses that you're explaining, like taxes and anything more expensive. Outside of 14 days, you're not entitled to that. If they cancel within 14 days, then you're entitled to your money back or a new flight, and you're in compensation territory. So I think from what you're saying, you're outside of 14 days.
Sorry, say it again.
So because they canceled,
the line was bad.
Sorry, because they cancelled on you more than 14 days in advance, you're only entitled to your money back or a new flight. You're not entitled to anything else.
Yeah, it's unfortunate because, the way they book the flight, the prices of the flight, I know it's not your fault, but just, it's unfortunate because, the flight, when you approach 2 weeks before, like for Christmas time, flights can be like 4 times the same,
Yeah, I totally understand that. I mean, it's one of the reasons why we have this 14-day rule. So if it's within 14 days, the laws, which is called EC 261, it's a European law, but we now have our own version here in the UK. Basically recognizes that there's not much you can do, therefore you're entitled to compensation. But when it's more than 14 days, you're not going to be entitled to that compensation. And at the moment, if a cancellation is due to The pandemic, if it's caused by that, it'll be what we call an extraordinary circumstance, and you can't get compensation anyway. So I think it's one of those really unfortunate cases where there's not much you can do, I'm afraid. It's very, very difficult. There's not so many flight claims at the moment because of COVID. And I'm guessing this flight was probably moved because of that anyway. I'm only saying that because of the timing of it. Most flights that have been cancelled or moved has been because of pandemic over the last 6 months. Not much you can do. But as I say, in any event, always, if it's outside of 14 days, there's nothing you can do anyway. More of your questions coming in. So I received a text saying that I can jump the waiting list for the COVID vaccine if I pay £150. Is it legal for me to do this? Anyone know the answer? I know you're all screaming at the screen because we all know the answer to this. Forget about the legality. This is a scam. And I'm hearing lots of these every single day. There's so many vaccine scams doing the rounds at the moment. This is a common one. You don't have to pay for the vaccine. You can't pay for the vaccine because there is no one selling it unless they're selling it to the government. No one's selling it to you and me. Therefore, this is a scam. And if you paid, the person that asked me this question, if you paid for it, you'd lose your money, but you certainly would not get the vaccine. So if it came by text, delete it. Came by email, delete it. Do report it to Action Fraud as well. In fact, do that first, then delete it. But anyone else watching, so many vaccine scams at the moment. The only thing that's going to be genuine with a vaccine is if you are in the right category to receive a vaccine. You only have to go on the NHS website to see who is the current category, those that are vulnerable, elderly at the moment, receiving the vaccine. And if you get a letter that doesn't ask you for any money whatsoever, then you're probably receiving something genuine. But if in doubt, call your GP. Because they will be able to tell you if it seems likely that you should have received an invitation for the vaccine. But jumping the queue, sorry, that's always going to be a scam. Next question. I ordered a television online. As soon as it arrived, I could see that it was too big. Do I have the right to return it? Good news here is yes, you do, if you are still within 14 days of delivery of that television. Now, because when you buy things online, and let's face it, at the moment, we're all buying things online because we can't walk into shops. What the law recognizes, and the law is called the Consumer Contract Regulations, the law recognizes that when you buy online, you can't touch the goods, you can't go and see them, or if it's clothing, you can't try them on. And therefore, you need to have some rights to return the goods if you don't like them, they don't fit, too big for your house, as in this case with this television. You need to have that right, and indeed, you do have that right. So here, because it's a television, it's not what we call a bespoke goods or perishable goods, because with bespoke or perishable goods, the rule I'm telling you about now does not apply. You can't send them back. But when it's not in one of those two categories, you can, so long as you are within 14 days of delivery. So the answer here is, yep, it's too big, send it back. You often will have to pay for the cost of sending these goods back. Let's face it, this is not the retailer's fault. The only time that they have to pay the cost of sending goods back is when the goods are faulty and it's not your fault. In all other circumstances, you ordinarily have to pay yourself. I say ordinarily because some retailers are really good and will pay this for you. You just need to check their terms and conditions and see what they say. But as I say, often you won't have to do that. Let's see if we can take another phone call. Nearly took another phone call, but it went off. So let's go back to your questions. My energy provider has sent me a bill for unpaid energy dating back to 2019. Can it do this? Answer, no, ordinarily. So let me tell you when they can't do it. We've got something called the back billing code, and it says that energy providers should not back bill you for past supplies they've not billed you for already for more than 12 months. So they can go back for 12 months, but they can't go back beyond that. The only time that changes is if they've not billed you because of something that you've done. So if you've hidden or you've changed your meter, done something fraudulent, in those circumstances, they can go back and bill you. But in all other circumstances, they can't. So if they do, just go back and say, back billing code, sorry, no. Let's see if we can grab another call. Not doing very well with these calls. They're coming in, but I'm too slow to answer them. So we've got another call coming in. Let's see if I can take this one again now. Hello. This person doesn't want to speak to me. So I submitted a chargeback claim for a long-awaited refund, which was initially provided. My bank has since taken the money back. What can I do? Look, unfortunately, this is happening quite a bit at the moment. Let me explain why. First of all, let me say they are allowed to do it. So what happens with a chargeback is that you have paid on your debit card or maybe your credit card. You can do a chargeback claim with either. A chargeback claim is basically when you have paid with one of those methods. You think something's gone wrong. The goods are faulty. Perhaps they've not arrived or some issue you've got. You can go back to your bank or your card provider and say, something has gone wrong. Can I have my money back? And let you go and basically fight it with the trader. They effectively claw the money back. Now, let me start off by saying this. You have to make these claims within 120 days of the date of the transaction. Very important because lots of people miss that point. Often the bank will just say, okay, here's your money back. But then if the trader comes back and disputes this and says, well, here's some evidence to say that this consumer's wrong, the bank in those circumstances will claw the money back off you again and give it back to the trader. So you have to be very careful with these claims. If this happens, and it's happened here with this person, you can go back and dispute it. If they say no, that's the time to trot off to the financial ombudsman and see what they have to say about it. But ultimately, I'm afraid it can be done. Good evening. What's your question?
Hello.
Hi there. What's your question? Can you hear me?
Yeah, I can hear you.
What's your question?
Hello.
Hi there.
Hello, mate. You all right?
Yes, thanks. What's your question for me?
Well, basically, yeah, we booked a holiday to go to Wales.
Okay.
In New Year, yeah. And obviously we couldn't go to Wales because of COVID. It closed down on the 21st of December.
Yes.
Yeah. And they won't give us. Well, they want to give us 75% of our money back. They're saying they're obliged to stay solvent, and they want to take £400 for administration costs.
Right. Guess what my answer to that's going to be? No.
Pardon?
I said, guess what my answer to that will be? The answer will be, of course, they can't do that. So look, they've cancelled because of COVID, obviously. They're trying to withhold some money. And what you're saying is they've got an obligation to stay solvent. Yes, they do, but not with your money. That's the important point.
Okay.
The only thing they can do is they can withhold a reasonable admin fee. And when I say reasonable, I'm talking maybe £10, £15, something to that order. Certainly not £400. They are just in the wrong.
Yeah, well, it's 25%.
Yeah.
400 is 25%. They want to take 25%.
Yeah, well, that's just ridiculous. And that is a legal term. How did you pay for this holiday?
Yeah. Pardon?
How did you pay for the holiday?
A bank card. Over the phone.
Debit card or credit card?
Debit.
Okay. And when did you pay for it? Are we still, you may have heard me just say this, but are you still within 120 days of when you paid?
I can't hear you.
When did you pay for it?
Hello?
Hello?
It's going all funny, the phone.
Isn't it strange that during can you hear me? When did you pay?
Yeah, I can. You keep going in and out.
Okay. Look, let me end that call. But if you're listening online, I can continue to answer your question. Look, you've paid by debit card. That means you can make a chargeback claim. What I was just speaking about a moment ago. If you are still within 120 days of when you booked and paid for that holiday, if you are, this is what us lawyers call a slam dunk case because they cancelled. I've always known what the law is when a holiday company cancels a holiday, but apparently many holiday providers didn't know what the law is, but they now do. They do, because not only have I been telling them, and other lawyers have been telling them as well, but the Competition and Markets Authority, the CMA, they've been telling everyone. So it's very clear. That means that the card company, your bank, will know that you're in the right. There's been a breach of contract, not giving the rest of your money back, and they will give your money back. So if you're within 120 days, that's the route to take. You will get your money back. There's no doubt. Now, if you're outside of 120 days from when you booked this holiday, chargeback's going to fall by the wayside. There's nothing you can do about that, apart from just going back to this company and pushing them again. You've heard me speak about this quite a bit this evening. Small claims court. This is going to be your final step that you take if you can't get anywhere. Again, slam dunk case in my opinion. If you look on my website, theconsumerlawyer.blog or theconsumerlawyer.co.uk, you'll see there's lots of information on there about how to take companies to the small claims court, how you forms, and what you need to say. But ultimately, I think you're going to be just fine with this issue. You'll get your money back. I'm sure also there's going to be many other people out there that have got the same issue as this as well, because despite me thinking a few weeks ago that we were coming to the end of disasters with cancelled holidays, weddings, events, clearly we're not. Clearly it's still going on. So for those people that are in that situation, let me just recap what you would do. If debit card or credit card, try the chargeback claim first. If you're outside of 120 days and you used your credit card, then you go and try a Section 75 claim. These two claims are quicker than going to court and should be easier. I always tell people this: when you claim the first time to your bank or your card company, they are going to say no. Why do I say that? Am I psychic? I may as well be, because they do it every time. So I know it's going to happen to you. Go back and ask them for the second time. Often when that happens, they say yes. Now, if they say no, you've got two more options. Either financial ombudsman to complain about the card company or the credit card company that they've rejected your claim when they shouldn't have done, or as I say before, the small claims court. That's the way to go. Now, for those watching who are Teletext holiday customers, desperately waiting for your refunds, and I know that many of you have been waiting 6 months, 8 months, some people this month it'll be 12 months. It's just way too long. Why do I say it's too long? Because the package travel regulations say that you should have got your money back in 14 days. You haven't. You should have done. As you'll know, I have been pursuing the Competition and Markets Authority, the CMA, asking them to investigate this matter. Last week, we did one of these live streams dedicated just to Teletext holiday customers waiting for a refund. I sent that live stream to the CMA, and I'm pleased to say that today they've come back to me, acknowledged the live stream. They've told me they're looking through the live stream at the evidence that we've provided. And in fact, there was lots of good evidence in there. There were more than 1,000 Teletext customers that joined in that live stream, whether it be during the live stream or slightly afterwards, and gave their evidence. This is really good evidence. And the other update I'll tell you is that they are now also looking at the Trustpilot for Teletext and looking through comments, or should I say negative comments, that customers have been making. Again, really good evidence for the CMA. So I'm hopeful, can't promise it, but I'm hopeful that maybe, just maybe, an investigation is going to follow soon. Or if not, at the very least, they'll be having discussions with them in order to push your refunds. I'll keep giving you updates about that as and when I hear it. But that's the current update about it. It sounds promising to me. And that communication came straight from the chief executive's office, straight from the top. So I think it will be good news coming soon. But again, I can't promise it. Before I carry on, I just want to remind you of one very quick thing. The advice offered during this live stream is for guidance only. You should always seek your own independent legal opinion. And do remember there's some rules. And the number one rule is that you must never tell me the name of the brand that you are complaining about. Just simply say airline, retailer, shop, dodgy builder, or something like this, but don't tell me the name. Thanks very much for that. So it's a very quick, I'm thanking myself because of course that was my voice recorded earlier, but I do need to remind you of that very important reminder. Let's go back to some of your questions. James, can we ask for a caravan park to give a full breakdown of fees? To date, they have refused. James, go onto my website, the consumerlawyer.blog or consumerlawyer.co.uk, and you will see that I've written extensively about caravan parks, because during the summer last year, lots of people approached me about this. And I guess it's where you're going with your question. They were saying to me, look, the park is closed because of the lockdown, and we now can't use the park, but we're still being asked to pay for the full pitch fees and other annual fees. Is that right? My answer to all those people that asked me that question, of thousands, by the way, was clearly, no, it's not right. You're going to be entitled to a partial refund. And the reason for that is that the Consumer Rights Act says that you must always get what it says on the tin. Here, pitch fees, it'll be cleaning the site, security, and all the other things. And we know that during these lockdown periods, there's very little security. Often they're not cutting the grass and all the other things they're supposed to be doing. You can't blame them for not doing it, by the way, but they're not having to expend their money on that. Therefore, you'll be entitled to a refund. Now, for others listening, why has James asked that question? I can tell you why he's asked it. Again, I'm not psychic, but I know why. It's because he wants to see the full breakdown of the fees, so he knows what they're charging for, but they're not supplying. This is the evidence I've been given to people quite a bit. James, the answer to your question is you are fully entitled to receive that information. You should ask for it in writing first. You could go to the small claims court with it. I don't think you'd need to. If you pay these fees with a credit card, you could make a Section 75 claim saying, I've not got all what I've paid for, and you would be successful with that claim, so long as they can't say, well, actually, we charged for 3 things and we've supplied all 3. My experience is that's probably not going to be the case. Next here, David says, telesales agent exaggerated services. Is this mis-selling or misunderstanding? Well, what do you think? When a salesperson exaggerates something, there is a line, and there's a line they may cross. And if their exaggeration causes you to make what we call a purchasing decision, I say those words because that's what lawyers call it in court. So if you're persuaded by something that a salesperson tells you to make that decision, and it turns out that that information that persuaded you to make the purchasing decision was wrong, then that is mis-selling. And if you're mis-sold goods, you're going to be entitled to a refund. Often people come to me and say, I was mis-sold a sofa. Sometimes they're right, sometimes they're wrong. The type of scenario where they'll be right is if they're told, here's a sofa, it's 100% genuine leather. Hear this quite a bit, by the way. And let's say it's not 100% genuine leather, it's an imitation. Now, in that case, in those circumstances, that's a clear case of mis-selling. And there, you'd be able to get your money back. Another common one I hear with sofas is, I went in the store, I sat on it, it was really comfy. The salesperson said, yep, the one that's going to arrive in your house will be just like that one in the corner. And it arrives at your house and you sit on the sofa and it's rock hard. That's potentially not mis-selling because it's not had use. So the one in the corner of the warehouse, loads of people have sat on that sofa and it's got softer over time. That's not mis-selling. The salesperson should have told you that it's going to take a bit of time, but it doesn't cross the line. So I hope that answers the question. But often if a salesperson exaggerates something and it leads you to make a purchase, often that's a good sign to say it's going to be mis-selling. And it happens very, very often, we know, with all sorts of things, especially cars, by the way. Back to your questions. Lots of people are very pleased to hear the news of Teletext and the CMA. Me too. I hope this leads to something. I really hope it does. I do not believe that the CMA can now turn a blind eye to this, because too much has been given to them, not just by me, but by you as well, you consumers that are in this situation. There's a couple of groups that were set up with some people that have been brilliant advocates, actually, and leading these groups, have done amazing jobs to push this out there. There's some other people in the media that have helped as well. So I think between all of us, we have just produced way too much information for this to go away and for the CMA not to take notice. So hopefully they will. Back to your questions, see what else we've got. I've been waiting 9 months for my refund from a holiday provider. Am I able to start charging interest? This is a great question, actually. And you know what? If it was me, If I was waiting 9 months for my refund, I'd be charging interest. I'd try to charge interest. They would come back and say, well, unless you take us to court, you can't do that because there's no contractual relations that allows you to do it. So let's take a scenario. I've been waiting for my holiday refund. So you've booked a holiday and they should have refunded you 6 months ago. Your contract with that holiday company is you're going to pay money. They're going to provide you with a holiday. If they fail to do that, they're in breach of contract. Or if they fail to do it because of the pandemic, they're not in breach of contract because of the pandemic. So it's what we call an act of God. But in these circumstances, they have to give your money back. But nowhere in those terms will it say, we'll give your money back plus interest. So you can try, but there won't be a legal basis to sue them under it. But if you go to the small claims court, you can claim interest on the amount. The small claims court, the county court, has a default interest rate of 8% per annum. So that's what you would charge. So the answer to the question is yes, if you want to charge interest, you'll have to go to court or just ask them the question. We know often I won't mention companies' names, but I'll mention Teletext because we've mentioned it a lot. They've been keeping people waiting a very, very long time. Is it fair and reasonable for them to pay some interest to those who've waited? Of course, the answer to that question has to be yes. Do they legally have to do it? Unfortunately, no. But I think it's worth you asking the question because it's just taken so long for them to do this that will be the fair and reasonable thing to do. If you're really passionate about the interest, go to court. I've heard lots about Section 75 claims. Yeah, me too. When you buy with a credit card, but I bought something with a debit card and the shop won't give me a refund, is there any cover from using a debit card? Yep, we've spoken about it quite a bit this evening. It's called the chargeback claim. So Section 75, as you've quite rightly identified, only applies to credit cards. But when you pay with a debit card, you can make a chargeback claim. I think I said it earlier, make sure you make that claim within 120 days. If you fall outside of that, the right is gone. And the reason for this is that this is not underpinned by law. So what that means is no act of parliament, there's no legislation that says that debit card providers have to provide you with this chargeback scheme. All the banks, all the debit card providers have clubbed together to voluntarily do this, but they've put their own rules in place. The main one being the limitation period, the 120 days. So it's very important that you get that claim in on time, failing which you just lose the right forever. If you pay by debit card, credit card, you can also do a chargeback claim as well. If that goes wrong, again, I've said it before tonight, but I'll just keep saying it because so many people don't realize this, that with Section 75, with credit cards, you can go down a Section 75 route. Why am I surprised that people don't know? Because we've had this law since 1974. And for some strange reason, many people still don't know about it. But now you do. Let's see what other questions we've got. It's an interesting one. Will I be better to go through the small claims court or do a Section 75 claim on my credit card? Karen, you don't tell me what this is about. Maybe I can guess that it's to do with Teletext or a holiday company. But my view is you're better off now going down the Section 75 route. Let me tell you why I'm saying now. Because 6 months ago, nearly every single Section 75 claim was being rejected. Remember what I said earlier? They rejected them the first time round. But 6 months ago, during the pandemic, the card companies were confused. They were thinking that actually these holiday companies had a good defense and therefore they wouldn't pay out. They were wrong, I'm pleased to say. So now it's become easier. So here's the reasons why I would say Section 75 before you go to court. Number one, it's quicker. Number two, it's easier because you haven't got to fill out court forms. You haven't got to wait for a defense, go to court and everything else. It doesn't take months and months. And number three, you're more likely to be successful with a Section 75, even if you've got to go and ask twice. And remember me saying this, and I don't apologize for keep on repeating myself. The first time round, they're going to say no. The second time round, they're most likely going to say yes. When I say they, I mean your card company. That's the way to go. So Karen, try the Section 75 first. If that doesn't work, you can then go down the court route or complain to the ombudsman. If you're looking at how quick you can do it, then I would say go down the route of the court if the Section 75 doesn't work. Let's see what other questions we have very quickly. We are looking at taking TT to the small claims court. Can we do this and one claim under the lead passenger? We are 2 couples for the total amount paid. Tina, it really depends. If you all booked together under one contract, then yes, you can do it in one claim. If you booked separately, you paid separately, there's 2 separate contracts, then you can't do it together unless you do what's called a group litigation order, which you wouldn't do for just 2 couples. So my advice here is, I know it would be better to do it this way. Of course, it would be desirable to do it in one claim. But of course, there may be some slight differences in your claim. I know you're saying, well, why would there be? Because we were going together. There may be in terms of the way you paid or the responses you've had or something like that. So my advice is no, do it separately. Again, I keep saying it, if you did pay by credit card, perhaps try the Section 75 claim first. And if you've done that and been unsuccessful, or if you just want to go down the small claims route, please do go to my website, theconsumerlawyer.blog or .co.uk, because as I said, I have put some information and materials on there to help if you're making a small claims court. And remember the first call we had, I think it was the first call this evening, from I think it was Adrian, telling us how we had sued the wrong party. It wasn't Teletext, it was something else. Let me reinforce that. It's so important. If it's Teletext, don't go and sue them as Teletext Holidays. That's not their name. That's their trading name. So with them, it's going to be Truly Travel Limited, or anyone else watching this is going to sue. Make sure you sue the correct party. And again, I'm saying this so much because I know so many people are going down the small claims route at the moment. It's going to be very, very busy for them. That's it from me this evening. I hope that I got to your question. If not, I'm back on air Friday evening on LBC from 9 p.m. for 1 hour. If you have a question for me there, you can give me a call on 0345 6060 973 or text 84850. Or as always, you can send me a tweet at Dean Dunham or at LBC. And if you do that, I'll answer your question on Friday evening, or if it's after Friday, on this live stream again next Monday. Next Monday, I promise we've got some new software. The telephone calls will work much, much better, but it's been an experience. I hope that this has helped. Certainly that's what it's designed to do. Do keep on sending me your questions. I will try and answer as many as I can on this live stream and on LBC. In the meantime, I hope you all stay safe. Again, be careful if you're suing anyone through the small claims court. Make sure you get the right party, and make sure that if you make a Section 75 claim, you do not take no for an answer, because the second time round, in my view, it always works. Good evening to all of you. I'll speak to you hopefully on Friday or next week.